Alex here with a legal nuts and bolts video on legal malpractice. Some people call it attorney malpractice. I do get some emails on this topic. I just wanted to go into really one of the big things that I think people aren't looking at when it comes to legal malpractice, and not go into too many details. I tried that and the video got too long. So with any of these lawsuits for civil damages, it's not enough to show that the other side did something wrong. You also have to show that because of what they did, you suffered some kind of damages. With ordinary lawsuits, these things are often interconnected. Like if somebody hits your car, you just have to show like they were driving it and they were doing something negligent, and then you just have to show how much damage it did to your car. It's, for the most part, it's in your face. It's kind of obvious. With legal malpractice, it's not. With legal malpractice, what it means is that you have to show that the case that the attorney was supposed to represent you incompetently would have turned out differently had you had a competent attorney representing you. In other words, you can't just expect the judge or jury to automatically assume that if you show the attorney committed malpractice in your case, that you automatically would have won the underlying case. It doesn't work that way. You have to separately deal with the underlying case. You have to separately show that that case had merit and that you would have won that case. And it's not going to be just assumed automatically based on the attorney's incompetence or malpractice that you would have won. This is a very real thing that actually does happen. Attorneys do go in to court and say that it doesn't matter that they committed malpractice. It doesn't matter that they were negligent. And the reason it doesn't matter is because had you had competent legal counsel, the outcome would not have turned out any different. People don't think that's fair. It gets under people's skin. It seems cheap because it almost seems like they get away with what they're doing. But if you want to have an attorney disciplined for having done something wrong, you're going to have to just use the grievance process through the state bar. That's what they're there for. If you want to file an actual formal lawsuit against the attorney, you have to follow all of the rules that they put into place and that they apply to all of the other types of civil damage lawsuit cases. The same rules that apply to all those other cases apply to a legal malpractice case. And so that is one of the reasons why, as cheap as it may sound, attorneys can go in there and say that the outcome wouldn't have been different anyway. You wouldn't have won the lawsuit anyway. You wouldn't have gotten a better judgment anyway. You wouldn't have gotten a better settlement anyway. And they can do that, and they often do that. So I guess a couple other things I wanted to mention. Look into the statute of limitations, because my understanding is that it's shorter for legal malpractice lawsuits. I don't know how long it is off the top of my head, but I think it is 1 year in Nevada. There's other types of lawsuits with statutes of limitations of 3 years, 4 years, 6 years, maybe even 7 years. 1 year is considered comparatively short. The other thing is, I know with some of these malpractice lawsuits, you have to attach an affidavit of merit. With medical malpractice, I'm absolutely sure of it. If you file it in the district court, it has to have an affidavit of merit. And that's basically an affidavit that's prepared by like a doctor for that type of case. With the legal malpractice lawsuit, you might actually need one of those affidavit of merits to be filled out by an attorney. If you don't attach an affidavit of merit in a medical malpractice lawsuit, they can easily dismiss the case. I assume the exact same thing applies to a legal malpractice case. So just check into that. It's not going to be something that's in like the Constitution or like the common law or a court rule. It's going to be something that's probably in your statutory scheme. So check the statutes. The third thing I wanted to mention is I have no idea to what extent you may have to pursue an appeal for one of these cases to be able to be actually brought against an attorney. Look into that to see if you have to have filed an appeal or win an appeal or something like that. Or even if an appeal say an appeal isn't mandatory, look in and see if an appeal would impact the case itself. Maybe winning an appeal helps sort of get around some of the requirements in a legal malpractice case. I don't know. Look into that, please. That's one of the things that jumps out at me. I think with that being said, I'm going to go ahead and end this video. If anyone has any questions, feel free to post them in the comments below. I'm sorry I don't know everything about legal malpractice. I never did any research on it myself. I never looked into it myself. I hardly ever used an attorney. So when it came to my cases, it was just me representing myself 90% of the time, 95% of the time, something like that. I'm going to actually do the math when I go into my docket series. I'm going to go and do the math as to how many papers I filed on my own and how many times I went into court and represented myself and come up with an actual percentage, because right now I just kind of guess it's 90 or 95%. But anyway, what I'm saying is I hardly ever used an attorney, so I really didn't have any motivation to look into legal malpractice or anything like that. One last thing is, this is very different from what they use in criminal cases to get criminals out of jail. What they call it a ineffective assistance of counsel. I may do a separate video on that. It's very different. It's based on the Sixth Amendment, which legal malpractice is not at all based on. So, okay, I think at this point I'm going to actually end the video. Go ahead and post something in the comments below if you have any questions, or send me an email. I will see you guys next time.